societal, structural, and systemic factors which contribute to IPV and impede survivors' inabilities to recover. Today, we're going to share the time for our talk. So I'll begin by giving you some background about family violence, specifically IPV and coercive control. I'll situate this discussion within the landscape of remedies that exist for survivors of IPV or the lack thereof. Second, Jennifer will explain the Ahluwalia decisions, both the decision and the trial decision and the Court of Appeal decision. And following that, I'll provide our critique of the decisions, followed by a discussion about myths and stereotypes perpetuated, including by the husband's lawyer. And Jennifer will finish with our concerns about failing to recognize a tort of family violence from an access to justice perspective. So IPV, I'll begin with some of the terms that we're using. The tort of family violence drew its name from the Divorce Act, which was amended in 2021 to include family violence for the first time. The Act now has a broad definition of family violence, which includes physical violence, sexual abuse, financial abuse, threats, harassment, including stalking, and threats to or damage to property, including pets. This includes conduct that's criminal as well as non-criminal, and the Act is also clear that it includes coercive control. So we now have this definition, which serves like an umbrella term. It includes violence by an intimate partner, as well as between family members, so a grandparent to a grandchild, siblings, and so on. So underneath that umbrella term is intimate partner violence, or what we'll refer to as IPV. IPV encompasses all spousal violence, including violence by a non-married partner. It includes physical violence, individual acts, and coercive control. There are many types of IPV, which we won't get into, but there's one that was important because it was reflected in the facts of Ahluwalia, and it was argued as an alternative tort during the appeal, and that is coercive control. So coercive control focuses on the tactics and patterns of abuse that undermine a survivor's autonomy. It's important to think of this in the broader context, not as isolated events. The impact of the ongoing abuse on the victim is what's critical. Tactics can include isolation, manipulation, humiliation, surveillance, microregulation of gender performance, economic abuse, intimidation and threats, as well as acts of physical and sexual violence. IPV is gendered. Women are disproportionately victimized by their male partners. Marginalized women are also disproportionately victimized, including Indigenous women, members of the queer community, disabled women, and those living in rural and remote communities. That said, IPV can be experienced by persons of all genders and sexualities. IPV can also take on different forms for different groups of survivors, including identity abuse for queer and trans survivors, abuse related to immigration status, and spiritual abuse, which can occur alongside other systemic inequalities. So this is also why we've used an intersectional feminist analysis, which does not exceptionalize IPV. In terms of the impact of IPV on victims, there's a broad range of harms, including trauma, PTSD, complex PTSD, physical consequences, financial implications, and disadvantages in the legal system. There are a broad range of health conditions linked to IPV, including chronic pain, diabetes, heart disease, and more. Victims also commonly suffer from traumatic brain injuries, and IPV can also lead to death. Financial abuse and the financial implications of IPV are also important. Victims often have poor credit, housing issues, are unemployed, and have few to no assets. Poverty and homelessness are linked to increased vulnerability to IPV. So securing financial compensation for victims is also a way to help prevent future violence. In the last 2 years, the federal government adopted a national action plan on gender-based violence. The Minister of Justice and the Attorney General of Canada declared gender-based violence to be an epidemic, and the government is currently considering criminalizing coercive control. Federally appointed judges are now legislatively required to have training in IPV, and gender-based violence experts, including ourselves, are also increasingly recommending that lawyers be trained in family violence and intersecting experiences and trauma. So it's within this context that Ahluwalia was heard. So before turning to the case, I'll explain some of the existing compensatory remedies that exist for IPV. To be sure, torts are not common for IPV, and this is likely for a few reasons. First, interspousal immunity once prohibited wives from seeking damages in tort, but those laws were reformed in the 1970s and 80s. Despite the availability of tort law, pursuing tort remedies has remained uncommon. Another perceived impediment was Frame and Smith, which is a 1987 decision from the Supreme Court of Canada. In that case, the father had sought damages for the tort of intentional infliction of emotional distress for the mother's interference in his parenting time. In not awarding damages, the case became synonymous with the idea that tort remedies in family law cases were barred. However, as we'll discuss in a minute, the Ontario Court of Appeal in Ahluwalia clarified that Frame does not bar all tort actions in family law cases, including for IPV and including for the intentional infliction of emotional distress. In Frame, there was a legislative answer vis-a-vis parenting, which was not true for IPV. Second, other torts have been recognized in family law. And third, IPV is pervasive. To the first point, family law provides very little statutorily to compensate for IPV. The move away from fault-based divorce brought a prohibition on considering misconduct in spousal support cases. Today, IPV may be relevant to victims' need, which can ground entitlement, but the amount that's ordered is going to be limited. Property legislation sometimes allows unequal distribution when a party has incurred debts recklessly or depleted assets in bad faith, suggesting financial abuse. There's also exclusive possession orders and protection orders, but they only offer temporary relief. Outside of family law, there's limited legislative options. Victim compensation laws exist in some provinces and territories, but not all, and may be restricted to pecuniary losses. Where victim compensation is available, it's often restricted to those who have reported the violence to the police. And this is also true of restitution orders under the criminal code. Civil protection orders sometimes provide financial remedies, i.e. the abuser making ongoing mortgage or rent payments. And social assistance is often not available because of work and immigration requirements, and it's often inadequate and limited when it is available. So we turn to tort law. The tort of battery, the tort of assault, the tort of intentional infliction of emotional distress are all available for IPV-related wrongs. The torts of harassment, stalking, and non-consensual distribution of intimate images are also available in some jurisdictions. However, one of the key arguments in Ahluwalia was that the existing torts provide a patchwork of remedies that a broader tort of family violence would better encompass, including coercive control. So I'll now turn it over to Jennifer to discuss the Ahluwalia decisions. And she has a mouthful of water.
Thank you, Deanne. And thanks to Anthony for the invitation. It's great to be here. So by way of overview, the parties in the Ahluwalia case were married in India in 1999. They had one child there and immigrated to Canada in 2001, where they had a second child. In 2013, the wife was diagnosed with major depressive disorder and moderate anxious distress, which were a result of the intimate partner violence that she experienced at the hands of her husband. The family struggled financially, and their finances were described by the trial judge as tight. The parties separated in 2016, and the trial was heard for 11 days in early 2022 on issues related to support, family property, and the wife's claim for damages for family violence. With respect to the intimate partner violence, Justice Renu Mandhane accepted the wife's evidence of the husband's emotional and financial abuse and coercive control, finding that he had insulted and belittled her, including about her difficulty conceiving. He threatened to leave her and the children penniless. He subjected her to silent treatment, which only ended when she complied with his demands for sex. He controlled the family finances and monitored her spending. And he was also physically violent on 3 separate occasions, including an incident of strangulation. The husband was criminally charged with assault and a count of uttering death threats in 2021, which were still outstanding at the time of trial and at the time of the appeal in this case, but they were ultimately dismissed. In her decision, Justice Mandhane accepted the tort of family violence and awarded $150,000 in damages, consisting of $50,000 for each of compensatory damages, aggravated damages, and punitive damages. She recognized that this overall amount was high, but still found that it was justified in the circumstances. So there's a few things that we would like to highlight from the trial decision. At first, the husband suggested that recognizing a tort of family violence would lead to weaponization of family litigation. Justice Mandhane disagreed, citing the 2021 reforms to the Divorce Act that Deanne mentioned, and also an access to justice rationale that survivors should not have to file both family and civil claims. Second, she acknowledged that a tort of family violence overlaps with existing torts, including assault, battery, and intentional infliction of emotional distress. Yet she held that this tort of family violence was fundamentally different in terms of assessing liability, causation, and damages. The starting point for this new tort was the Divorce Act's definition of family violence. And then using that starting point, Justice Mandhane went on to frame the tort as having three different modes of liability. First, conduct that is violent or threatening. Second, conduct that constitutes a pattern of coercive controlling behavior. And third, conduct that causes the plaintiff to fear for their own safety or that of another person. The first and third modes of liability were said to require intentional conduct, so that's consistent with existing torts. But the second mode of liability, Justice Mandhane found to be unique compared to the incident-based approach of existing torts, because this pattern of coercive controlling behavior recognizes the cumulative types of harms that are associated with coercive control. Here, Justice Mandhane indicated that the person must engage in calculated conduct that included more than one incident of abuse, using the list of tactics from the Divorce Act definition, including physical abuse, sexual abuse, emotional and financial abuse, threats, and so on. She offered multiple rationales for accepting the tort of family violence. First, existing torts are insufficient to capture intimate partner violence, including their vulnerability to missing relevant social context, and also the fact that existing torts allow for greater engagement in stereotypical reasoning, which is problematic. Second, she noted that the Divorce Act does not provide remedies for the harms and financial barriers that are caused by family violence. And here, Justice Mandhane noted that the negative financial and social impact of family violence is almost exclusively borne by the survivor. Third, she relied on comparative jurisprudence and Canada's international human rights obligations, which also support the recognition of the tort of family violence. And then finally, she found that recognizing this new tort would be consistent with societal and domestic obligations, including the idea of normative personal responsibility as an important standard in society. Therefore, the husband was found liable under the tort of family violence for his psychological, verbal, financial, and sexual abuse of his wife. Alternatively, Justice Mandhane found that he was liable for the three specific incidents of physical violence under the tort of assault, as well as for the intentional infliction of emotional distress, given that his conduct was flagrant and outrageous, calculated to produce harm, and it caused the wife's depression and anxiety. So those are essentially the elements of that tort. Returning to the damage award, the compensatory damages were found to be related to the mental health impacts that the wife experienced because of the abuse, including past and future care costs and lost earning potential. And Justice Mandhane noted that this was distinct from the spousal support that she had ordered under family law, which was insufficient to cover the wife's mental health needs. The aggravated damages were awarded for the husband's coercive control and breach of trust, including the fact that he preyed on his wife's vulnerability as a racialized newcomer woman to Canada. Importantly, the aggravated damages also included recognition of the impact that the husband's actions had on the children's mental health, which in turn made it more difficult for the mother to care for the children. And then the punitive damages, Justice Mandhane noted, could have been higher, but the fact that the husband was still facing criminal charges at the time of trial led to her limiting those damages to $50,000. So then the appeal. The husband appealed, but did not dispute the factual findings of abuse. Rather, he argued that the tort of family violence should be overturned, and also made arguments about the extent of the damage award. In a unanimous decision written by Justice Mary Lou Bonado, the Ontario Court of Appeal agreed with the argument that the tort of family violence should be overturned, while at the same time emphasizing the pervasiveness and seriousness of intimate partner violence and family violence. In doing so, they upheld liability for the intentional torts committed by the husband, but reduced the damages to $100,000, finding that Justice Mandhane had erred in awarding punitive damages. The primary issue on appeal, therefore, was whether the tort of family violence should be recognized, and if not, the wife argued in the alternative that the tort of coercive control should be recognized. The Barbara Schleifer Clinic and Luke's Place filed a joint intervention in the case, advocating for the tort of family violence to be upheld. They disagreed with the alternative of a tort of coercive control because they argued that this would contribute to the existing patchwork of torts that makes it problematic for survivors to bring civil claims forward. They argued that the tort of family violence had the power to remedy the systemic abuse of trust and confidence within a relationship, and also noted that it could be applied flexibly and holistically, which is important for considering how violence may impact different women differently. In declining to recognize both of these new torts, the Court of Appeal didn't dispute Justice Mandhane's rationales, but they held that existing torts were sufficient in this case, including in relation to the patterns of behavior which Justice Mandhane thought was unique. They noted that the tort of battery can encompass multiple instances of physical violence, as occurred in this case. The tort of assault involves the apprehension of imminent harm or offensive contact, which includes the sort of fear that survivors may live under, as occurred in this case. And they also found that the tort of intentional infliction of emotional distress was met in the case at hand. The Court of Appeal also disagreed that existing torts don't sufficiently capture the violation of trust that's inherent in intimate relationships. And they disagreed with Justice Mandhane's starting point, which used the Divorce Act definition of family violence, finding that this definition was only relevant to parenting disputes. And then finally, the court also declined to recognize a new tort of coercive control. This tort, as framed by Ms. Ahluwalia, would have eliminated the need to prove harm, only requiring conduct that was calculated to cause harm. By way of comparison, the tort of intentional infliction of emotional distress does require proof of harm. And the wife in this case had argued that the elimination of this harm requirement filled a gap for victims so that they wouldn't need to prove their emotional injuries, which has been recognized in the literature as often providing a barrier for these types of cases. But the court disagreed and found that proof of harm was necessary. Finally, and Deanne will speak to this more in her critique of the cases, but to foreground our analysis, the Court of Appeal was also concerned about the impact that a tort of family violence would have on litigation strategies in family law. They feared that it would cement an adversarial approach to family disputes and undermined the movement towards consensual resolution. Ultimately, the court thought existing torts were adequate in this case, and they overturned the tort of family violence. And I'll now pass it back to Deanne to provide our analysis and critique of the decision.
Thank you. So the traditional objectives of tort law, deterrence, compensation, and corrective justice are all relevant to IPV. However, we must also attend to the historical trajectory of women's lack of access to torts and other economic remedies based on their lack of legal personhood and power. This means that tort law theories have not traditionally focused on interspousal harms or intangible harms that tend to be sustained mostly by women. Indeed, tort law has undervalued these harms and the women who claim them. for instance, through the lens of the reasonable man and the protection of spousal harmony. Existing torts such as assault, battery, and intentional infliction of emotional distress also require intent, and it's challenging to prove that, as well as injuries involving dignitary and autonomy-based harms. Past studies indicate that even if damage awards for IPV-related torts were made, they have tended to be quite low and often connected to criminal convictions. This is problematic for survivors who do not seek protection from the criminal legal system, including those who have experienced systemic racism, colonialism, and other forms of oppression. We agree with Martha Chamalis, who spoke earlier in this series, that more compensatory social justice objectives, such as equality and considering the context of lived experiences, must inform the development of tort law, including for IPV. The trial decision in Ahluwalia went some way in moving tort law forward by recognizing the need for a tort of family violence and by applying it in a case involving intersectional inequalities. However, the Court of Appeal's reliance on existing torts maintained the incident-based approach to IPV, which Justice Mandhane held did not sufficiently capture the cumulative harm associated with the pattern of coercive control. To be clear, an incident-based approach to IPV will tend to maintain the hierarchy of physical harms over emotional, dignitary, and autonomy-based harms, given that the latter are more cumulative and harder to see in nature and impact. Despite this, the Ontario Court of Appeal claimed that existing torts could address the patterns of abuse. We argue that the case law they described generally shows otherwise, reinforcing the challenge for survivors to fit their experience into discrete events and discounting the whole. The Ontario Court of Appeal also failed to deeply consider the contextual relevance of the violence occurring within an intimate relationship of trust, contrary to the guiding principles of a feminist approach. Nor did they engage with the intersectional considerations that may contribute to the dynamics involved and the harms suffered. In addition, while the Ontario Court of Appeal found that the intentional infliction of emotional distress was a sufficient basis for recognizing emotional harms related to IPV, the requirement to prove intent and specific injuries is more burdensome than the tort of family violence as framed by Justice Mandhane. That being said, we think Justice Mandhane's modes of liability should be expanded, particularly the second mode that focuses on coercive control. She found that this mode required the plaintiff to establish that their family member engaged in behavior that was calculated to be coercive and controlling. Calculation suggests intent, and we argue that a lower bar, such as recklessness as to the impact of the conduct, should be sufficient. But as non-torts experts, the issue of appropriate standard of culpability is one that would appreciate feedback on in the Q&A. We do note that using recklessness would be analogous to the tort of non-consensual distribution of intimate images. This tort is legislated in many Canadian jurisdictions and includes a standard of knowledge or recklessness as to the lack of consent to distribution. A lower standard would also be consistent with the definition of family violence in some family law legislation. For instance, the BC Family Law Act was explicitly amended to indicate that intent is not required for a finding of family violence. So now to myths and stereotypes. Another major point of commentary on both Ahluwalia decisions regards both courts' simultaneous repudiation and perpetuation of IPV myths and stereotypes, including in relation to lawyers' ethics. An accepted definition of myths and stereotypes is that they are assumptions and expectations that are false or faulty and are linked to disadvantaging beliefs, attitudes, and narratives. IPV myths and stereotypes serve a social function by blaming victims and exonerating abusers, and they operate to deny, minimize, or justify the abuse. Victims are also subjected to additional layers of myths and stereotypes based on assumptions connected to their race, indigeneity, sexual orientation, gender identity, disability, and socioeconomic status. Indigenous and racialized victims are often seen as blameworthy for violence, and their reasons for not leaving or reporting abusive partners are often ignored or misunderstood. We argue that tort law has developed in the shadow of IPV myths, so its harms have been privatized, minimized, viewed with suspicion, or expected to be endured. When lawyers advocate using IPV myths, this can be re-traumatizing for survivors and can contribute to institutional betrayal. It also serves to confuse legal issues, mislead the court, and unfairly surprise the victim, as well as waste court resources, all contrary to lawyers' obligations to the court and the administration of justice. For example, one of the most pervasive IPV myths is that women lie about abuse to gain a tactical advantage in family law. It's raised as a defense by perpetrators and their counsel. The claim of fabrication rests on stereotypical beliefs that women are manipulative, vindictive, and deceitful, and it's typically not accompanied by any evidence that supports the allegation. In Ahluwalia, the husband's lawyer perpetuated this and other harmful IPV myths and stereotypes. During cross-examination, the lawyer asked the wife why she didn't complain to the police after the husband physically assaulted her. She suggested that the wife only sought medical attention after the husband said he wanted a divorce, suggesting an attempt to obtain false evidence of abuse. The lawyer argued the wife should not be believed because she had immigrated to Canada with the husband after the first incident of violence, perpetuating the "why didn't she leave" myth. And she suggested the wife was more likely to have fabricated the IPV because she was cast in a movie about IPV post-separation. The narrative that the lawyer constructed was that the wife lied, claiming her damages pursuant to the tort of family violence out of anger and to gain a financial advantage. The lawyer also perpetuated the longstanding myth of the hysterical woman. This stereotype is relied on to explain away violence by suggesting the survivor is irrational and therefore what she says is unreliable. In Ahluwalia, the wife suffered mental health issues related to the IPV. The husband's lawyer tried deflecting her client's responsibility by suggesting situational causes, including immigration stress, a miscarriage, and the parties' so-called difficult relationship. These suggestions pointed to the wife's irrationality and a lack of causation of harm by the husband. In her written closing, the lawyer also argued that creating a tort of family violence would encourage family law proceedings to be weaponized, and that children would be negatively affected. This argument relies on the stereotype that women are vengeful, even if it would harm children. In other words, the bad mother stereotype. Lawyers' professional ethics currently fail to prevent lawyers from perpetuating harmful myths and stereotypes in their advocacy. There are few clear rules in family law or civil law more broadly that prevent lawyers from creating narratives based on myths and stereotypes. Based on my work in this area, we argue that lawyers should not rely on harmful myths and stereotypes because of their obligations to the court and the administration of justice. A recent case from the BC Court of Appeal, KMN, may help in this regard because it debunks the myth of false allegations of IPV in the family law context, indicating that such an argument should not be made unless it's evidence-based. In Ahluwalia, Justice Mandhane wasn't persuaded that the mother lied, but the lawyer's advocacy may have succeeded in infusing the case with doubt about the potential consequences of introducing a new tort of family violence, which were of particular concern on appeal. That said, the trial decision implicitly and explicitly called out several myths and stereotypes relied on by the husband's lawyer, including that the most significant harms to survivors are caused by physical violence, that family violence is not harmful to children unless they experience it directly, that survivors do not stay with or immigrate to be with their abusers and should not be believed if they do, that survivors who do not report IPV to the police or other authorities like medical professionals until after separation should not be believed, and that women are likely to fabricate IPV out of anger or hope for a financial gain. However, Justice Mandhane's decision may have inadvertently perpetuated other IPV myths. As one of her bases for recognizing the new tort, she suggested that IPV is uncommon, stating that the marriage before me was not typical, it was not just unhappy or dysfunctional, it was violent. That was a quote. As recognized by the Ontario Court of Appeal, however, it's a myth that IPV is rare, nor is IPV a private matter, according to the court. The Ontario Court of Appeal rejected other myths and stereotypes as well, including the myth that violence ends upon separation, and that indirect exposure to family violence is not harmful to children. However, the Ontario Court of Appeal's reliance on a patchwork of existing torts is vulnerable to ongoing stereotypical reasoning. A tort of family violence would require evidence and presumably education of lawyers and judges to appreciate the significance of seemingly unrelated tactics of abuse. Existing torts run a greater risk of compartmentalizing conduct and misunderstanding IPV. Both decisions fell prey to the argument that claims for damages for IPV could be weaponized in family disputes. Justice Mandhane stated that courts must be careful not to arm family law litigants to overly complicate the litigation through speculative and spurious tort claims. That was a quote. And Justice Bonotto said that for every claim that has merit, there are some which involve claims made for strategic reasons. We do note that false claims of abuse can sometimes be made, including by abusers themselves, which will be addressed a little bit later by Jennifer in her comments on access to justice. But as noted in KMN, this concern must be supported by evidence and not grounded in speculation. Instead of recognizing that a new tort could have possible deterrent, compensatory, and other positive effects for victims and their children, the Ontario Court of Appeal presumed the opposite, that a new tort would increase the hostility between the parties, leading to adversarial approaches to dispute resolution and fabrication. So this leads to the final issue that we'll address today, which is the access to justice implications of recognizing or failing to recognize a tort of family violence.
So our approach to access to justice in the paper uses work that I've done previously with Janet Mosher and Wanda Wiegers that recognizes both the substantive and procedural aspects of access to justice, and that prioritizes the safety, security, and autonomy of survivors. Using this lens, Deanne and I argue that parsing the lived experiences of intimate partner violence into legal claims based on different torts is highly problematic. This patchwork approach may reduce damage awards, and the overall complexity will often necessitate representation by legal counsel. Another access to justice problem with using a patchwork of existing torts for intimate partner violence is limitations issues. All Canadian jurisdictions have now amended their legislation to eliminate limitation periods in claims for assault, battery, and or sexual misconduct in the intimate partner violence context. However, these exceptions do not expressly cover the intentional infliction of emotional distress. This gap was recently noted in a case from Alberta called Colnut. In this case, the court rejected the wife's application to amend her claim to include the tort of family violence based on the Ontario Court of Appeal decision in Ahluwalia. The court then found that while her claims based on assault and sexual assault could proceed based on these limitation periods having been repealed, her claim of intentional infliction of emotional distress was seen to be limitation barred. The court's rejection of the tort of family violence in Colnut is problematic, as the facts include elements of family violence that may not be covered by existing torts, such as the abuse of animals. This application of Ahluwalia ignores the rationale of the Ontario Court of Appeal decision, which was that existing torts covered the facts of that particular case. We've been tracking decisions that have been released since the time of the Ahluwalia Court of Appeal decision. And it's just interesting because the trial decision led to a number of people trying to amend statements of claim or introduce claims based on the tort of family violence. But since the time of the Court of Appeal decision, trial courts have been routinely failing to recognize the tort of family violence, which suggests that Ahluwalia is being interpreted as a kind of blanket rejection of this new tort. The Colnut case also highlights that if a new tort of family violence is eventually accepted, this may require amendment of limitations legislation because, again, this tort is not explicitly mentioned in the repeal of previous limitation periods. We note that this particular recognition could be done contemporaneously with recognizing and defining a tort of family violence legislatively. So Deanne mentioned that there is now recognition of the non-consensual distribution of intimate images as a tort in legislation across Canada. And so similarly, a tort of family violence could be legislated and at the same time, limitation periods repealed. On the other hand, an access to justice advantage of the Ahluwalia decision is to allow tort claims to be heard as part of family law proceedings. This avoids multiple proceedings and allows a tort damages claim to be heard at the same time as matters in dispute in family law, such as support and equalization of property. However, we recognize that there are significant financial and enforcement concerns with civil claims based on the respondent's inability or unwillingness to pay. And here we'd note that there are very few claims in Canadian law that have been brought against institutional actors in the case of family violence, which distinguishes intimate partner violence from claims for sexual violence, where there often are institutional actors who are part of that litigation. There are also potential issues with insurance coverage of awards for intentional torts for intimate partner violence, which Melanie Randall wrote about back in the 1980s. Although here we note that some provinces have amended their insurance legislation to respond to this problem. To invoke the metaphor from Ahluwalia, another concern we have is with the possible weaponization of a tort of family violence by abusers. Using the legal system to perpetuate abuse or backlash is a recognized practice. For example, survivors have been hit with defamation actions for speaking out about abuse, which is well covered in Mandy Gray's new book, Suing for Silence, and it's great to see Mandy's name on the screen here today. Parental alienation accusations are also raised by abusers to counter claims of family violence. Perhaps surprisingly, given how deeply contested alienation is as a concept, a tort of parental alienation has been advocated, which would put women at risk of unfounded liability. The legal recognition of coercive control has also been weaponized, as seen in the family law realm, where women's protective actions have often been recast as coercive and controlling in themselves, leading sometimes to adverse parenting outcomes. So it's not a stretch to imagine that a tort of family violence would be co-opted by abusers against actual survivors, and that their claims would sometimes be successful based on the ongoing application of myths and stereotypes in this area. This, in our view, is a larger concern than that of false claims by women seeking so-called strategic advantage, revenge, or easy money. Returning to our suggestion of a legislated tort of family violence, this legislation could include a preamble or purpose statement that recognizes the gendered and other inequalities inherent in intimate partner violence. Such a statement could then be used as an interpretive tool to combat the possible misuse of the tort by abusers. More broadly, however, we also recognize that tort remedies and the private law system only go so far and can problematically align with neoliberal policies emphasizing individual responsibility. In the intimate partner violence context, torts individualize what is a systemic problem and often ignore structural factors that contribute to intimate partner violence, such as poverty and underemployment, which are in turn related to systemic racism, colonialism, ableism, homophobia, and transphobia. A more systemic approach to intimate partner violence would recognize that society bears some responsibility for the costs of this form of violence. So we argue in our conclusion that survivors should be entitled to publicly funded financial supports that address structural inequalities, including housing, education and training benefits, pay and employment equity, adequate employment benefits and social assistance, and properly subsidized childcare. But failing these systemic reforms, we argue that torts, including judicially created torts, can fill some gaps in economic need for at least some survivors. We argue that this will happen most effectively if the tort of family violence is recognized, exempted from limitation periods, made available in family proceedings, properly supported by access to legal representation, and is free of the application of myths and stereotypes by lawyers and judges. Thank you, and we look forward to your questions and comments.
All right, thank you so much, Jennifer and Deanne, for that interesting discussion. And hopefully the sorts of questions that you and issues that you raise will be taken up by the Supreme Court if leave is granted in one way or another. So following our usual practice, I'll open up the floor to questions for our Q&A. I think that I'll be taking the cue. I think the easiest way to do so is to use the hand raise function on Zoom. Either that or use the chat, I guess, to get onto the queue. So as people start formulating their questions, I think I'll kick it off, and then I'll see Zoe's raised her hand, but if you don't mind, Zoe. So I think one of the questions that I have is, in a way, just trying to see what you would say to one of the sorts of impressions that I got from the case that is maybe not so critical of the decision. So, supposing that the Supreme Court doesn't grant leave in this case, and the Court of Appeals decision is final here, one of the ways I've been teaching my students about sort of not seeing this as a kind of a huge loss for dealing with intimate partner violence is that the court is trying to do something to develop existing torts to cover this new situation. I mean, part of the claim is that intentional infliction of mental suffering and battery, for instance, are already covering this sort of fact scenario. But I think other things that the court is doing is clarifying the nature of these alternative causes of action, but also developing them a little bit in order to better capture this scenario. So instead of saying we need to recognize a new tort and put a name on it, we can sort of build up piecemeal existing torts. So for example, what if the courts were to say, well, we can look at existing torts of assault or battery or something like that and develop them to be able to capture issues like cumulative harm, or one of the things you mentioned was harm to pets or animals in the household, to be able to capture that under an existing tort. It's not so much putting a name on intimate partner violence as it is moving that fact scenario under an existing cause of action by extending the cause of action. One of the other things too, I thought that was like helpful about the case, about the decision was, you mentioned the concern about proving psychological harm on the part of claimants. The court said, there's this, one of the elements of the IIMS tort is to prove visible and provable illness. It seemed like it was a difficult evidentiary hurdle. But the court said that given recent developments in negligence law from the Supreme Court, there's no need to prove a recognized psychiatric illness and use expert evidence. Sadati and Moorhead says just standard testimony is going to be helpful for this without having to use DSM diagnostic criteria. So in a way, that's also developing the IIMS tort to kind of soften it and the evidentiary burdens in order to capture the situation. So you guys, I guess there's two sorts of methodologies here. One of them is creating a new tort, putting a name on this problem, which I think has its own benefits. Another is to say, well, we can sort of coherently work with the existing structure of torts and expand them in a way to capture this new situation. So do you think that there's at least something positive to take in that respect from the decision?
You want to go? Maybe I'll start.
Okay.
So interesting question. Thank you for that, Anthony. I think, the fact that we're coming at this from a perspective that draws on feminist literature that has critiqued the application of torts over time is very significant, because what that literature shows is that existing torts often haven't proved satisfactory in these types of cases. And so even if the Supreme Court, for example, has said we don't need a recognized psychiatric illness, I think what the literature shows is that Nevertheless, the type of injuries that women tend to suffer as a result of intimate partner violence and sexual violence, especially those psychological harms, have not tended to be recognized by the law. And I think that's potentially an ongoing problem with using existing torts. Same thing with respect to, the Ontario Court of Appeals point that existing law recognizes patterns of behavior. If you actually look at the descriptions of the case law they cite in that part of their decision, almost all of the cases are incident focused. It's talking about multiple incidents of mostly physical violence rather than really recognizing coercive control. And here I would say that another project I'm working on is reading all of the cases decided by lower courts subsequent to the Divorce Act amendments that try to grapple with this notion of coercive control. And courts are struggling there too, like the difference between a sort of overarching pattern of conduct that over time cumulatively results in particular types of harm is very different from, saying multiple incidents add up over time. And I think that's something that courts continue to grapple with in different areas of law. So recognizing a new tort of family violence is not just to me about naming the tort as such. It's about really grappling with what that means in terms of recognition of coercive control. I don't know if you have anything to add to that.
No, that was a great example with, I mean, I guess I do, but great example with reading all the cases, because what I was thinking about was just the struggle that survivors would need to go through to try to articulate and find those incidents in order to try to figure out which torts to use and which incidents of had occurred of abuse throughout the relationship could be a 20-year period, and just the challenge of that in itself. I mean, we have a new challenge if there was a tort of family violence to try to ensure that lawyers and judges are able to understand and figure out coercive control, which, as you're suggesting, they're already struggling with. So that's a different problem, but I think that's a problem that leads to a better, like it's got a better outcome if we go with that problem.
Okay, I think so. I may have some follow-up, but I'll go through the list first and come back at the end if there's time. So I have Sashi Karim Paz and then Jason Nyers.
Hi, yeah, it's Tzachi Keren from Sheffield. So thanks a lot. I really enjoyed the talk, and I have a few questions and comments. The first is about you mentioned at the beginning that the phenomena is gendered, and also that it affects disproportionately marginalized groups. But you also mentioned queer. So I would like some clarification. How do you mean LGBT? And if so, is the incidence higher, lower? So it seems to me to be a bit tension with the claim that it's gendered and referring to the IPV claim in the context of the queer community. So I would appreciate some clarification on that. Then the second thing is partially an observation, partially a question. And again, I haven't read the case, but my understanding from the summary is that the trial judge alternatively said that there could be liability, based on, traditional torts, of intentional infliction and the battery. So was there any difference in what she quantified as damages according to this? Because if not, it suggests that in her mind, perhaps there isn't that a need for the new tort, because the same damage could be awarded by existing one, which leads me also to think that the sticking point in having the new tort is in cases in which there's no evidence of physical or sexual abuse, and then the only way forward is for the economic and other forms of abusive control. A quick comment about intent. So again, it's been some time since I engaged with Canadian tort law, but in tort intent could be either to act, just to act, or to act and to harm. So if the intent is to act, so in many cases, the tort could be in effect strict liability. And actually, in my recent book about NCIIs, I argued both normatively and also, based on recent decision in England, that the tort of breach of privacy and misuse of private information could be understood as strict liability tort, despite the fact that it's an intentional tort. And then the last two comments, one about autonomy. So again, just to mention that I belong to the camp that the things that tort law and also specifically negligence has a role in protecting against mere injuries to autonomy, and I've written about it before. And the last comment is that you might want to have a look at Israeli court decisions. Israel has a generally expansive approach to tort law, also in family settings, but specifically, I think that there were some cases in which there was tort liability for failure to give a religious divorce get that leaves the woman without an ability to remarry. So there were some cases that imposed liability for that. But thank you very much.
Lots of questions.
Yes.
I could start with the first one, which I believe was how can coercive control or IPV be gendered if it's also, or was it the stats and the data that you were looking for in terms of the queer community?
Again, you mentioned the queer. Obviously, I'm well aware of intersectionality and the fact that many cases of abuse are not only gendered but also disproportionately affect sometimes the gender minorities and racial minority and so on. It wasn't clear to me how in this case the claim is that it affects more marginal views, including queer community. So do you equate queer with LGBT? Is the claim that there's more IPV among lesbians than among heterosexual or among gay men? So this is what I'm interested in.
So sort of, I think, so yes, I was equating queer with LGBTQ2S+. And I think that there's data, there's stats that show that they're disproportionately, the queer community, if we use that label, are disproportionately affected, meaning there's quite a bit of IPV and coercive control within the community, but there's also not a lot of research on it at the same time. So like I think it's Luke's Place right now is currently doing, looking for participants to do a study to try to gather, which is a shelter, IPV shelter here in Ontario, to try to gather more data, because there just isn't a lot, and what exists talks about how it's misunderstood. So for instance, if a woman goes to a shelter and she's a lesbian, and then the same shelter admitting her abusive partner to the shelter. And so just how it's misunderstood, and then how shelters and police and lawyers are then not responding effectively. There's also debates around how coercive control is understood, because coercive control being first defined by Dr. Evan Stark and really looking at it in a heteronormative, gendered theoretical structure. And then debates following from that as to, okay, so does this apply to the queer community? How does it apply? And I believe the current is that it still applies because the power struggle is what's the core issue, not so much the how and the specific tactics. So there's still the dominant issue, or the core central concern being how power is manipulated within the relationship. And so in that sense, that's still, but again, there's not a lot of data and research. So I don't know if you know more, like
No,
data
I mean,
you're pulling from?
I think that's right. There was I think 2018, it was Statistics Canada report on intimate partner violence amongst sexual minorities. So that's the one that we cite in our paper. There's also some really good research out of Australia and other jurisdictions as well on identity identity abuse specifically. So when 2S LGBTQ plus identity is actually used as part of the abuse. And we cite to some of that research as well in our paper. But yes, it's still, I think, fair to say, an emerging area. Then there was also just a question that you had about, whether this ultimately in some ways comes down to damages and if that's kind of driving some of the analysis here. And I do think the finding of coercive control as part of the umbrella of family violence was significant in the Ahluwalia case, because that in particular seemed to be something that Justice Mandhane mentioned as relevant to aggravated damages. So if the claim had just been brought on the basis of existing torts, and there hadn't really been analysis of family violence and coercive control, perhaps that could have come in under intentional infliction of emotional distress, but it was something she mentioned specifically under that head of damages. And then you've given us lots of other good things to think about, so thank you.
Thank you.
Okay, and then in recapping the list, I missed Zoe before, so I'll ask her to chime in.
You didn't miss me. I took myself. I said everyone could speak before me is what I said. So you were not skipping me. You knew where I was. Okay. So thank you so much for this. I find this topic interesting, and I really know what I think about it. So part of me. So I mean, I am a tort scholar, I guess, in that way, and so I'm not. I don't. At one point, I think, Deanne, you were talking about, the goals of tort law. I'm gonna put all my cards on the table. You're like, corrective justice, deterrence, and all these other. I'm not like a functionalist with respect to tort law. I don't see it as another form of regulation. I think if it is, it's really bad at all of this. It's really expensive. It's really old and doesn't really fit things. And so it's not like, if you're looking to a tool to combat family violence, I'm going to say tort law might not be what you want. At the same time, there is something, I think, so the way I would approach this, which is like, you take it or leave it. I think there might be, from a rights-based perspective, I actually think there might be a distinctive wrong that is involved in cases such as Ahluwalia, right? But okay, so you might not want to go through, because I'm going to tell you where it might make you end up, right? So there's a sense in which, think about like sexual violence in the context of family relationships. So you think about fathers and daughters and that. So there's something like, it's not just sexual battery, right? There's a distinctive type of wrong here, because it wrongs a particular type of relationship. So like with your feminist perspective, this works. There's a type of relational wrong that's happening here, which actually in rights-based scholarship, like, is a type of right. So it's a right that parents have with respect to their children, right? So I was talking to my colleague Jason Nyers about this a long time ago. He's like, yeah, so you kidnapped my child. Not only have you wronged my child, but you've also wronged me. So you've interfered with the relationship that I have. So there seems to be in these cases of family violence, the distinctive type of wrong that's going on here has to do with like a violation of a particular type of, like a status relationship, one that's constituted by, we can call it imperfect obligations between the spouses, right? So spouses do have obligations towards each other, which are not actually enforceable against one another, right? But the failure to satisfy these obligations can be grounds for divorce, for example. So there does to be like a distinctive type of like legal wrong that happens in a situation that is actually more than just battery, more than just, I find coercive control to be a kind of a complicated thing to understand, because it's not, I'm not quite sure. Like we don't have a tort, for example, of like hypnosis or manipulation, right? We just don't have those torts. So I'm not sure how that could go through. Okay, so that's fine. So like, I think there actually might be a distinctive type of wrong here and then that makes sense for me. Like then like there's a distinctive type of interpersonal wrong. Then yeah, tort law needs to be there, because that's what tort law does. Tort law addresses interpersonal wrongs. Like on my, like I'm going to say, admittedly, very narrow, slightly limited view of what tort law is and what tort law is not. But of course, then this puts you in this like awkward situation where you might find yourself now advocating the return of various torts that we have gotten rid of. So these are the amatory torts, right? And so I'm like, if we think that there actually is this kind of like type of status relation rights that you have vis-a-vis your spouse, right? To not treat you in certain ways or to treat you in certain ways, then we get into the problem, we get into like a distinctive type of problem where, and it's actually might not be a problem after all. Like you might think that we actually have codified this kind of relationship in Family Law Act, for example. So if you negligently or intentionally damage my spouse, I can go after you right, for damages. And so I think the best justification for this is that you've interfered with a right that I have vis-a-vis my spouse, right? So so I think, but so you might end up in that situation, but you might also in a situation where you're like, well, listen, now you've cuckolded me, and now I can sue you for that. You might not want to go there. So I just think that maybe has some sort of, if you want to use tort law, I want to know why tort law is like free. And there's like answers you can give, like, listen, the expressive value, like Martha Schmalz's answer, the expressive value of tort laws. We want to say that this is a distinctive type of wrong, and for that or more, I think the point is, like, if we say it's not a distinctive type of wrong, what kind of values is tort law expressing, right? That could be one avenue, but I want to know what it is that tort law does that maybe criminal law couldn't do, or other types, or family law, more robust type of family law wouldn't approach. But anyway, thank you so much for this. I enjoyed thinking about this, and I enjoyed your comments.
You want to go?
Sure. Yeah, there's a couple different ways to approach what you're saying, and it's super interesting to hear you think of it as like that relationship wrong, and to try to use that lens. And they didn't frame it quite that way, but it made me think of the Luke's Place and Schleifer interveners, their factum. So they kept talking about the relationship of trust, and that this is a relationship of trust, and that was a distinct place and a distinct issue. And so it's a little sort of beside what you were saying, but it's just sort of made me think of that, because that is a big piece of what was missing to me in the Court of Appeal decision, was that recognition of just what this relationship is and the depth of the wrong, because it's an intimate relationship. And so to your question of why tort law, part of it is because we don't have a better answer, because if we look at family law, if we look at criminal law, for example, I mean, criminal law already doesn't criminalize coercive control. And if we're just looking at just the economic, trying to get some money into the hands of the survivor, and then family law has got limits on that. So spousal support would be the obvious place to start in family law. And so the harms caused by IPV are relevant to whether or not there's non-compensatory spousal support, but the way spousal support is structured is it's limited. And so you're only going to get so much, and non-compensatory spousal support is more reduced in terms of the quantum and duration of spousal support than compensatory, which IPV would not be relevant to. So there's not a lot of avenue in there. And then also taking the fault-based piece out of family law, there's an overall resistance to reintroducing it. And so that's also a sort of a minefield and quagmire to navigate, because even though fault-based divorce was overturned, we now have no fault divorce. It doesn't mean fault or abuse doesn't occur in relationships. It still does. And so trying to navigate getting some economic support for the survivor in that structure is very difficult. It's a little bit like what you were saying about tort law, in the sense of we're trying to go back, like we're the danger of going back to where we've come from. And then how do we move forward with it? So I don't know if you wanted to add.
I guess the one thing I would add, like, just thank you for your comments. And it's really interesting to think about the relationship focus here. I guess the one thing that I would add is just that, yes, coercive control is, I think, a very new way of thinking about abusive relationships. But ultimately, it is about autonomy. Like, if we think about the types of harms that coercive control exacts on the victim, it is very much related to autonomy-based harms, related to, their isolation and manipulation, and just other ways in which their will has been impeded. And so, given all the great feminist work on relational approaches to autonomy, for instance, like, I think there's maybe some interesting work that can be done here in bringing these concepts together. So, although I do also recognize the concern about resurrecting these old torts. I mean, we're already worried that a tort of family violence is going to be weaponized. And I think if it opens up some of these prior torts, that concern is only amplified. But thank you for the comments.
I love those old torts, though. So yeah, it would be great. All right, thanks.
They're kind of juicy.
Criminal conversation, yeah.
Okay, thanks, Zoe. So Jason and then Joanne.
Hello, everybody. Thank you. This is the first of these series that I've come to, and I'm just unsophisticated tort lawyer, but I had to. I mean, I don't disagree with Zoe, but I actually wanted to add something else because I had some students write papers on this in advanced torts, and they put me onto something that I had kind of thought of before, but they reinforced it. And really is, I think that the torts of analogy you're looking for, everybody looks to the wrong ones. Okay, they look for a battery, which is sort of a interference with your right to bodily integrity, or they look to the intentional infliction of emotional distress, which is an interference with your sort of mental integrity, which in a lot of these cases, these things are happening, but that's not the gist of what our concern is. And it's sort of this idea you've been saying about coercive control. Now, what is the tort that deals with coercive control? And that's a tort of intimidation. Of course, it wouldn't occur to people to look at that because it's generally seen as a business tort, but it has the exact structure we're looking for, that somebody wants to do something and they're dissuaded from doing what they want by threats of wrongs being committed to them or to things that they care about. And the courts have no problem, of course, dealing with that in two-party intimidation. And so for me, Ahluwalia, I think, is really a two-party intimidation case. In the English courts, in a case called Goodwin, I can never pronounce the second, Uzwage, they recognize that it could be used outside of the purely commercial perspective. And so that's where I would suggest for people who want to think about in tort law, that's the more natural analogy is to the tort of intimidation. And that deals with the question of just autonomy, because the danger with autonomy, of course, is autonomy is monadic. It's all about what you want to do, but there's lots of things I want to do that people stop me from doing, like winning prizes and getting the last thing at the grocery store that I want for dinner. So the tort of intimidation takes it and turns it into a bilateral. So what sorts of autonomy or what sort of control can people rightfully impose on one another? So that was what I wanted to add, that I think there's something there, and I think you're right. That's about this course of control over time, and it's not individual events, but that's the tort of intimidation, I think, or something close to it. So those are some ideas that I had.
Can I ask a question? Do you know if the tort of intimidation has been applied in a family law case in Canada?
I don't. I don't. So I didn't come across any when I was updating the book. But although this Goodwin case from England is usually the leading one that people will go to and look to, and of course the common law. Although we tend to think of it in factual terms, it's conceptual terms. So it has a certain structure. If that structure can replicate itself in a family law situation, there's no reason as a matter of principle that it shouldn't replicate itself, was what I would say. And it replicates itself better than some of these other analogies. So why don't we choose, if we're going to make an analogy, maybe we should choose the best one, would be my sort of view. And I think that would be the best one.
Interesting.
Very
Thank you.
interesting, yeah.
Thank you. And so, Joanne, if you're still here.
Yeah, I had
Okay.
actually typed mine out thinking I would take off. I have been following the development of the coercive control work out of England and Wales, where the real pioneering criminalization happened. And I had read somewhere, and I just can't remember where it is offhand, that there have been some evaluations indicating some serious problems with evidence. And I'm wondering what lessons learned we can get from how to apply coercive control. I mean, it hasn't hit criminal, well, it's marginally hit criminal. There's been a case in Quebec where it was used as an exacerbating factor in an assault, but what can we learn about better application of whatever we're going to do with coercive control from lessons learned out of the England and Wales?
Do that.
Yeah, thank you for that question. So I mentioned that I'm involved in another project with Janet Mosher and Wanda Wiegers, where we're looking at all the coercive control case law under family law. In some ways, I think that's a better analogy than the criminal context. And you're absolutely right that there have been concerns about the impact that criminalization has had in England and Wales. But given that we're dealing with a different burden of proof there, we're also relying on police making the decision to lay charges. In some ways, I think, there are limited analogies to be brought there. But from what I understand of the lessons learned there, as well as what we're seeing in the family law case law, it really does seem that judges are having a very difficult time wrapping their minds around the kind of evidence that will be supportive of findings of coercive control. They still tend to look for incidents. Every once in a while they will talk about patterns, but then it's more like, again, just like what we argued the Court of Appeal in Ahluwalia did, was look at patterns of incidents or multiple incidents over time, rather than thinking about, I think what is the really key perspective, which is what is the impact that this is having on the victim. So like, what are the sorts of autonomy-based harms that she is experiencing in terms of her ability to engage with the world, engage with the rest of her family, and so on. And it's kind of an interesting conundrum, because the fact that this is seen as a type of abuse that is so focused on the autonomy of the survivor also makes it very difficult to prove in a criminal context, because it places a huge burden on the survivor, number one, to have to give evidence about the terrible impacts that this abuse has had on them. But then, you know, that can also be a very re-traumatizing process in and of itself. And so I'm actually in the camp that says we need to be very careful about criminalizing coercive control because of the burden that giving that sort of testimony is going to have on survivors. But I think I take your overall point as being that we should look at what we can learn from attempts to legally recognize coercive control in other contexts and see if that can help us in the realm of torts. And I think it's a really useful thing to think about. So thank you.
Yeah, coercive control obviously is that drip, drip, drip effect. And it's very hard to shift our legal system on its ear like this to look at the pattern.
Mm-hmm. But even just going back to the facts of the Ahluwalia case, you know, Justice Mandhane talked about a few things. Where am I here? You know, insulting, belittling, threatening to leave her and the children penniless, subjecting her to silent treatment unless she met his demands for sex, controlling the finances and monitoring the wife's spending. You know, and individually, perhaps no one of those particular tactics would have led to a finding of liability in tort. But when you look at them cumulatively and at that sort of, as you say, drip, drip, drip effect that they would have had on the survivor and her autonomy, that's the sort of thing that we need to be looking for. And it'll be different in every case.
Yeah, thank you.
Thank you. Shannon Knight-Jones.
Hi there. I wanted to ask a question about how we get to the starting point before all of these solutions can even be sought. Because right now, what's happening is that many lawyers are advising survivors not to even raise the issue of family violence because there's no meaningful tools to actually seek redress. And so it'll just make the file more difficult, right? And because we're not raising it, the courts have this ridiculous, my opinion, ridiculous idea that it's rare. It's not rare, we're just not raising it because there's no tool to actually seek. So how do we, it feels like chasing one's tail, right? So how do you get to the point where you have lawyers willing to address the fact that there is family violence, even if there aren't meaningful tools that we might win on? We need to talk about it because the courts don't have a true perspective of how prevalent this is in their, especially in their high conflict, as they like to call it, family files, right? And one of the reasons I think it's really important, even if we don't have the tort, which would have been very nice, and we don't have specific ideas about which tort to try to get damages on, a person can gain their autonomy and freedom from further future damages if a court could just establish a finding of family violence and coercive control at the earliest possible opportunity, because it could interrupt the abuser's ongoing post-separation abuse, which is causing survivors lifelong debt while they are continually dragged back to court, right? So even if we can't get damages for the past, we can block damages that are in the future if a court would just hear the family violence and make a finding about it. So I wonder, how do we get lawyers to stop telling survivors to try and keep quiet and pretend to get along?
I thank you so much for that question. I spend so much time, I don't know about you, so much time thinking about that exact dilemma. Because you see it in all the literature, right? Like you see it, it's not just happening in Canada, it's in Australia, it's in the US, it's in the UK. It's so common and so pervasive that that's what lawyers tell survivors. I've also seen it in the criminal context. to not tell them to pursue anything because the system won't believe them. It'll be worse. And so as you're pointing out, that the problem with that is that it's like there's so many problems with it, but one of them is that it's also logical in a sense, because they're right that the courts probably won't believe them in many instances, that the whole process is going to be harder emotionally and financially than if they just didn't pursue it. So there's all of those problems. When you look at just the lawyer's ethics, I've tried to go down that road. And lawyers have an obligation to make sure that the facts that the court needs are in front of them, right? They can't lie to the court. So telling your client to omit something and leave out relevant facts and issues is not something lawyers can do. But at the same time, as I just said, it's completely logical that they're doing that. And it's up to the client what they want to pursue from the law, what their legal entitlements are. It's not the lawyer's choice for that, it's the client's choice. And if they don't want to put that forward, the complicating factor being parenting, right? So if it's about a child and family violence is relevant to parenting, we know that from the Divorce Act, it's the paramount concern, then we have an immediate tension that the court needs that information to be able to make a decision on parenting. And so there's a tension. And so I've gone down all these rabbit holes, as you can see, and it's so frustrating. And so the place that I keep coming out to is education. And that lawyers and judges need training and education on family violence. And I know we have that for judges now. We don't necessarily have that for lawyers or law students. I mean, I would argue that the changes to the Divorce Act require that at least family lawyers be educated and trained in family violence and screen for family violence, because they can't competently comply with their legislative obligations under the Divorce Act without the knowledge about family violence and without advising on family violence around parenting, and not just cases involving children, but also process, because it's relevant to what dispute resolution process is they choose. So they have to know about it in order to give competent legal advice. But you can also say that's just for family lawyers. And there's lots of data that shows that not all family lawyers screen or have training in family violence. And then when you look at legal education, there's not opportunities for law students. Not every law student gets education in family violence. I mean, you're teaching a great course now or seminar at Calgary. There's one at Lakehead. But unless a student opts into taking family law and that professor has chosen to include family violence, they're not getting exposure to it. So there's it's creating this problem, right? The courts are saying, well, it's rare. And so therefore then law schools are hearing, well, it's rare, so we don't need to have law students, and only family lawyers are going to need it anyway. And so it ends up in this tension of which is really frustrating to try to move forward. I don't know if you want to.
I guess the one thing I would add is Deanne mentioned earlier this KMN case from BC. We actually have a blog post, a little plug. We have a blog post on that case coming out on both SLAW and A blog, which is the Faculty of Law blog at the University of Calgary, on Monday. And one of the things the court says in this case, so it recognizes the myth of false allegations of family violence, says you can't just kind of throw that accusation out there without it being evidence-based, or at least courts should not be accepting it without some evidence. But it goes on to say how important it is for judges to make findings of fact with respect to family violence where it's alleged in a family law case. So it's a BC Court of Appeal decision. I really hope it sent the matter back for trial, but it's still got some really important statements on the role, not just of lawyers, but also of judges in cases involving family violence to make appropriate findings of fact and not just shirking their responsibility there. So I really hope that case will get a lot of pickup because I think if judges start feeling obligated to make findings of fact with respect to family violence, hopefully that will encourage lawyers, as well as the part about, being afraid of accusations of false allegations. I hope this case will go some way towards encouraging family lawyers of the importance to still raise family violence in their cases.
It's also the challenge of in family law interim orders, right, and motions. And judges just saying, well, we don't have enough. This is just a motion. It's just interim. We're not going to make a finding of family violence. We need a trial for that. And so few matters getting that far to trial, nor do we necessarily want family law matters to get that far to trial. And so you have this immediate we can't make a finding, we don't have enough, so we're just going to make an order without going down that road. you know, is a lot of the times what they do, and that's its own set of problems.
Yeah, they
Oh.
need to be stopping the entire process and not allowing anything to proceed until they gather the facts of family violence and make a decision then. Like they shouldn't be kicking it down the road 3 years to a trial, right? And then letting kids and women be harmed for those 3 years along the way, right? Or put at risk of worse.
I want to just
wanted
I just want
sorry.
to interject because we do have one more question to try and get in
sorry.
on the queue. So that's sorry to cut off a great discussion. Hopefully, you can continue offline. So, Allison, I know you sent a message wanting to get the last. We've got 2 minutes, so hopefully we can keep 30 seconds to a minute question and then response.
No problem. Thank you very much. Can you hear me?
Yes.
Okay, great. Thank you. I'm a practitioner in Nova Scotia. Thank you very much for all the work that you do. Very quickly, the reason why I think from a legal ethics perspective that we sometimes don't bring forward these cases is because I think we also have a competing duty to do no harm. And the question is, are we going to cause our clients more harm by running this case, by making them believe that justice will be served and then justice not being served? And I see this happen more times than not, and it's heartbreaking. And then it falls on the lawyer's shoulders to help your client off the ground and to put the next foot in front of the other and to move forward. And that's not fair to us. We've had 2 members of our bar commit suicide in the last several weeks. And so there's an enormous stress on lawyers who are dealing with clients and working within a court system that's not trauma informed. So those are some significant problems. I love the idea about being preventative. I think that will also stop claims of alienation. I think it could result in less costly and lengthy litigation. So I think that's a great idea. The challenge that we're facing in Nova Scotia is that we don't even have decisions, okay? So we're not getting any published decisions from certain judges, and I can't get the data. The court has denied me. I got a letter yesterday from our Chief Justice saying, too bad, so sad. Our Court of Appeal writes annual reports. This is their 2nd year they've done one. This is a great level of transparency. At any other court below that, we don't have it. And so what's happening is that we can't even there's no sense of accountability. We're getting really terrible oral decisions, and we can't have, say, the 1 or 2 judges that actually publish decisions say, well, you know, I disagree with Justice so-and-so and what they said in this particular case. We have no opportunity to do that. I'm desperate. I wrote my own endorsement on the last file that had DV because it was so terrible. Sorry, this is a comment. I apologize. I'm not even getting to a question. I'm going to go really fast. I apologize. But I just want you guys to know, because you're doing the important work at an academic level, but I'm in the gutter. Okay, I'm in the ditch. This is how bad it is. It was only because the lawyer on the other side, I think, felt so bad that the decision was so horrible. We wrote an endorsement. We filed it as a consent order and asked the judge to sign it, because I want to be able to hold up these 2 pieces of paper one day and say, this is how we got here. It's all filled with, you know, reasoning and everything else. It's horrific. So if you could turn, I guess this is a question of request for relief. If you could talk about the lack of published decisions and the impact on this field in particular, that would be very helpful. Apparently we call this a common law system in Canada. How is it if maybe 1 or 2% of all decisions are actually published? I can't even get the data point to say if my 1 or 2% hunch is correct. I think this is hugely problematic. Also, I think DV courts are really problematic. We have DV court, domestic violence courts in Nova Scotia. There's no discussion. There's no connection between DV court and family court. You've got 2 different two stories, 2 narratives running in 2 separate courts. They never talk. This causes huge problems. The perpetrator says, hey, look, I graduated DV court. I'm the best guy on earth. In family court, we're looking at the police records and different data, and we're saying, like, this is nuts. So thank you for everything that you're doing. Please don't stop. It's a hugely important issue. It is an epidemic. And thanks again. Sorry, no question there, just comments. And
no, I think it's a great call to action to end on, and the importance of the work that's being done here. So hopefully it provides motivation. Thank you for sharing your perspective, Allison. So Jennifer and Deanne, thank you very much. The final question was whether your article is published. I think you're still working on it, but my understanding is that there's a blog post on the Ahluwalia case on a blog, but I'll let you advertise your work. I don't need to do that for you. So.
Yeah, we have a blog post on the Ahluwalia decision, also on the Colnut decision that I mentioned, which is the one that involves the limitation periods. And then we have this new one coming out on Monday on the KMN decision from the BC Court of Appeal. And I think KMN probably links to our earlier blog post. So you can, if you just find the new one on Monday on either SLAW or a blog, that will link to our previous work.
Yeah, and yeah, you're right. The paper's not published yet.
Yes.
We're still working on it.
We
but
wanted to
almost
wait for
there.
the yeah.
Absolutely. Hopefully this discussion will inform its completion going forward. Thank you very much, and thanks everyone for a great discussion.
Thank you so much.
Thank you for having us.
Thank you.
Thanks, Deanne and Jennifer.
Thanks,
Thank
Melanie.
you.
Thanks for coming.
Nice to meet you.
See you soon. Bye.
You.
Thank you so much. Yeah, that was really great, and so much more kind of food for thought as well. I think it's given me. I think I'll start the class with Ahluwalia next time I teach.
Oh, neat.
Next year, so that there's more time in the class to talk about it. So,
Anthony, do you mind
yeah.
maybe just not closing the Zoom just yet? Because we just opened the chat and can see like all the comments here. So it'd be nice just to have a minute or two to read those.
Yeah, and the other thing I can do is I'm going to save the recording. It saves the chat. I can.
Oh,
Send
does it?
to you.
Okay,
cool.
great.
Yeah, and if you need to run, I'll send you the entire chat. You can see what was in it.
Oh, awesome.
Okay, that's great.
Great.
Thank you so much.
Okay.
Thank you. Okay.
All right. Nice to
Thanks
see you guys.
again.
Keep in touch.
Bye.
Bye-bye.